Supreme Court Justice Antonin Scalia was giving a speech at Rhodes College in Memphis, Tennessee on Tuesday night, and he said that he wouldn't be surprised if the Supreme Court rules that the death penalty is unconstitutional pretty soon. So that's an interesting claim. I don't know if they have a death penalty case coming in front of them in whatever upcoming sessions there are. But it's something that he said it. I think he's expressing something that in his mind is a legit concern because he obviously doesn't want to get rid of the death penalty. But the fact that he's bringing it up shows that he's like, I don't know, I feel something bubbling here. So the Daily Beast reports, quote, Scalia said no one should mess with the Constitution and that the death penalty should remain constitutional. Here's his actual quote. Do you really want your judges to rewrite the Constitution? Okay, so for those of you who don't know the history of this, in 1972, the court actually did rule that the death penalty was unconstitutional. So there was a brief period there in 1972, for a little while, a few years, where we didn't have the death penalty in America. But when some states, I guess, came up with new ways of doing it, and then it made its way through the court process again, and it got to the Supreme Court, they ruled, well, the way you were killing people before was unconstitutional, but now you're doing it more humanely, so it is constitutional. And then ever since then on, we've had the death penalty still. Now, there's been some challenges recently, but as of today, we obviously still have it on a case-by-case basis. Some conservative states still use the death penalty. But let's take a step back here, because if you listen to a guy like Antonin Scalia or Clarence Thomas and their philosophy of the Constitution, what they'll tell you is, look, all I care about is the original intent of the founders. So whatever the founders wrote and whatever their intent was, that's what I want to try to implement. Now, Scalia contradicts himself on this left and right, so it's kind of a bullshit claim that really is his philosophy and he tries to stick to it. But in this case, what would he argue? He would say, well, at the time that the Constitution was ratified, at the time the Constitution became the Constitution, we did the death penalty. So it existed. So the fact that they didn't get rid of it when they ratified the Constitution means that in their interpretation, the Constitution allows for the death penalty. So in his mind, he goes, case closed. That's it. Now, then there's the polar opposite view of the Constitution, which is the idea that it's a living document. And, you read it and you interpret it to go along with the times. I have like a middle-of-the-road version of interpreting the Constitution. I'm not in the only care about the original intent of the founders camp, because that was a totally different time and things were remarkably different. Again, at the time, they had slavery. And they fucking wore powdered wigs, and they were shitting in outhouses, and they didn't have the same technology or knowledge that we do now. So I honestly think it's silly to say just their intent is all that matters. I'm not in that camp, which is probably the furthest right-wing camp you can describe it, but I'm also not in the furthest left-wing camp, which is living, breathing document. You can always change it with the times, and whatever our new modern moral code says is okay. I'm in the middle ground. Now, the middle ground is what? I think you can go through the Constitution, read the different amendments, and you can use an interpretation of the amendment that doesn't, make stuff up to say, this is our new moral code, so we have to read it into it. But if you, through the plain language of the amendment, you can interpret it today as meaning something different than it did back then, well, then I think that's reasonable. So, for example, with gay marriage, I would have ruled in favor of gay marriage. And not because I'm just making this up and I believe in a living document and we should just pretend it's in the Constitution. No, I think it is a reasonable interpretation of the plain text of the language of the 14th Amendment, which says we grant equal protection under the law. I think a reasonable interpretation of that is, that also means for gays, and that also means specifically for them to marry. I think that's a reasonable interpretation based on the plain text of what the Constitution says. I'm obviously not saying that, the people who wrote the 14th Amendment had gays in mind, because they didn't. But when you read the plain text of it, it's a reasonable interpretation to say, well, it should apply to gays, and by the plain text of the language, it kind of does apply to gays. So that's how we're going to view it, and that's going to be what we take away from it. Now, having said all this, I go through all this to set you up for the 8th Amendment. What does the 8th Amendment say in the Constitution? Let me read it for you. It says, excessive bail shall not be required, nor excessive fines imposed, and here's the important part, nor cruel and unusual punishments inflicted. Let me repeat that. Nor cruel and unusual punishments inflicted. So the Constitution of the United States, the Eighth Amendment says the government cannot implement cruel and unusual punishment. Now, I submit to you guys, is killing people when, as studies have found, about 4% of the people who are on death row are innocent. Is that something that's not cruel and unusual? Is it not cruel to kill people when 4% of the people you're killing are innocent? I would say that fits the textbook definition of cruel. Is it not unusual to do the death penalty when a majority of countries in the world have now abolished the death penalty? So is that not unusual? Well, if we're in the minority in that sense, that would kind of fit the definition of unusual as well, because it's not usual. It's not happening in the majority of countries around the world. So I would submit to you guys that by the plain text of the Eighth Amendment here, you can easily say it is cruel and it is unusual to fucking kill people in a systematic way, especially when we get the wrong people sometimes, and especially when, as we saw recently, they stopped making the lethal injection chemical cocktail that they've been using recently. The pharmaceutical company that used to make it stopped making it now. So they're trying to come up with new ways to kill people, and we've had occurrences of people getting seizures, foaming at the mouth, being alive for 10 minutes, 20 minutes, 30 minutes after they got the injection, and then dying in excruciating pain, but you can't see it because they're paralyzed because one of the agents is a paralytic. So all that stuff, cruel and unusual. So you don't need to take the living document approach, and you don't need to take the original intent approach. You take the middle ground approach. You read the Constitution, you say, oh, we should get rid of it. So I like the fact that Scalia's like, ooh, I think we're going to get rid of it soon. And obviously, as you can tell here, I disagree with his interpretation that, well, we shouldn't get rid of it because do you want your judges to rewrite the Constitution? No, I don't. But what I want is them to read the plain text of the Constitution and, yes, have reasonable interpretations based on the plain text. And it is certainly reasonable to say that killing people, when oftentimes you get the wrong people, it is cruel and it is unusual.